Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. And today I'm here to give you a brief update on the Quartering lawsuit. That is Jeremy Hambly, the Quartering versus Matt Loader, otherwise known as Matt Fantastic or Prettiest Matt. Jeremy Hambly is a YouTube creator. Goes by the Quartering or Unsleeved Media, and he does content based around card games and board games. Matt Loader is a board game creator slash partial game store owner. Both of these gentlemen were attending Gen Con, and just before the Gen Con event, Matt Loader allegedly, and I don't know if we should still say allegedly because he has not denied doing it. We'll get to that in just a minute. But he has allegedly punched Jeremy Hambly, seemingly unprovoked, at least at the time of the attack. So that lawsuit is ongoing. And if you want to learn more about it, there's a bunch on my channel about it. However, today, just today, the 7th of February, a new document dropped. It was a case management plan that was jointly submitted. If you look right below my face, you'll see the case management plan sort of caption, which indicates Jeremy Hambly and Matt Loader and their attorneys. Jeremy's attorney is William Richmond, and the defendant, Matt Loader's attorney, is Stephanie Loshing, and their contact information is there, of course. This is filed in federal court, and this case management plan is a joint statement from the parties to agree to certain things about how the case shall be handled going forward. The last video I did was an update on jurisdiction because the two groups, the two parties were sort of disputing over the validity of federal jurisdiction, and I'll let you go watch that video for an explanation of it. However, I can tell you that this case management plan has resolved the jurisdictional issue. The case is moving forward in federal court. It will not be removed for jurisdictional purposes, and so the case will go on. This plan lays out the dates, the timelines, and stuff like that. Now, I've gone through it. Most of this is boring. It's a 10-page document. I've picked out the important stuff, and I'm going to start bringing those things up right now. So the first one, of course, is the parties and representation, which is right below me. It's also on the screen. You can see it at the top of the page there, just below the actual caption. But I'm going to start laying over the important parts of this document that follow. So the first one is a jurisdictional statement. Now, remember, this is a joint statement by the parties. It's signed by both parties, or by both parties' attorneys, which I'll show you at the end. So this is no longer in dispute. Okay, here's the first one. It says the party shall state the basis for subject matter jurisdiction. If there's disagreement, each party shall state its position. Now, the way this form works is it's a form produced by the jurisdiction that they're in, and it helps the parties formulate the makeup of the document and make sure they don't miss anything the court wants. So it's phrased there that the parties will state the basis for subject matter jurisdiction. Yes. They have done that, and that's this following paragraph. Jurisdiction is proper under federal diversity jurisdiction, 28 U.S.C. 1332. As the parties are completely diverse in citizenship, plaintiff is a citizen of Wisconsin, defendant is a citizen of Connecticut, and the amount in controversy exceeds $75,000 exclusive of interest and costs. Now, there was some dispute over that amount in controversy prior to this document. Matt Loader, through his attorney, Stephanie Loshing, had the opportunity to make a motion to dismiss based on jurisdictional grounds. They had to do that by February 1st. The only party who provided any jurisdictional evidence was Jeremy Hambly. He went ahead and provided a statement, a sworn statement, an affidavit, which stated the amount of losses that he had and the basis for those losses. Originally, Loader had opposed the amount of losses, and that's fine. However, when the time came to put up or shut up before the court, he did not put up, he just shut up. So they could have filed a motion to go after that diversity jurisdiction. They did not. So it's done as far as the court is concerned, unless something were to come up and the court would determine to re-listen to the diversity jurisdiction claim. Something big would have to change. Some new information, would have to come to light for that. All right, so now we move on to the plaintiff statements. The plaintiff statement of the case is that the plaintiff alleges battery and assault, primarily arising out of the following interaction. Plaintiff alleges that on the early morning, August 2nd, 2018, defendant punched him multiple times in the head while threatening to kill him. So that, of course, is laid out in the complaint. You can see my videos on the complaint and stuff like that if you want. If you don't know what's going on in this case, those are a good refresher. This will all be in the same playlist, so you should be able to find those videos pretty easily because my channel does cover a bunch of different content as well. So the defendant's statement is as follows. The defendant denies that he is liable for any damages. Now, this is an interesting approach because it doesn't say that the defendant denies the act of punching Jeremy Hambly. It just says he denies that he's liable for the damages that Jeremy may or may not have received from the alleged battery or assault. Again, it's a strange defense because if it's an alleged battery or assault, it doesn't mean the facts of the case or the act or whatever is alleged. It means that the legal conclusion of battery or assault is alleged. And that's true. At this point, there has not been a legal ruling on it, so that categorization of the events is still alleged. The facts do not appear to be in dispute. It does appear that for whatever reason, Loader is not denying that he punched Jeremy Hambly several times in the head while threatening to kill him. A strange approach. If I'm the attorney, I'm at least denying the threats to kill, even if you can't deny the actual battery, because those threats to kill are part of the element. But you know, I'm not Loader's attorney, so let's read on. So they denies that he is liable for any damages claimed by plaintiff for any alleged battery and or assault, and holds plaintiff to the strictest burden of proof for each claim and the alleged damages. Well, interestingly, the defendant doesn't get to hold the plaintiff to the strictest burden of proof, only the burden of proof of the court, which is a preponderance of the evidence. Means upon review of the evidence, does this seem likely? This is the nature of civil court. So that's the strictest burden of proof you're really going to get. In criminal court, it would be beyond a reasonable doubt, which is much more strict than what's going on in civil court. But these are very weird statements from the defense, but that's their strategy. Defendant claims that any and all damages claimed by plaintiff are the result of plaintiff's own negligence, which is a weird theory as well. Are they purporting some sort of alternate reality in which Jeremy was not punched, but maybe he ran several times into a window or something like that? I don't know. Again, very strange because they have not denied the actual attack in any of the documentation so far, and or are the result of the unclean hands doctrine. I talked about this quite a bit in a different video, but the unclean hands doctrine tends to involve contract disputes, not really battery claims. So I'm not sure what they're going for on the unclean hands. I think, based on some rumors and allegations that I've heard from people in the community, is that Loader is going to claim, Loader is going to claim that his actions were a reaction to statements that Hambly may have made at a previous date or maybe on a previous video. That's very interesting because there is very little, if any, case law to support the idea of violence as a result of something called fighting words based on something that happens outside of a temporal connection to the event. So like if I'm standing in front of you and I call you a bunch of mean names and then you punch me, Well, that might be because I provoked you into punching me. If I call you on the phone and call you a bunch of mean names, and then you get in a plane and fly to the place I'm going to be and get in a car and go to the place, and then you see me and then you attack me, there's no imminent reaction to the initial statements. So the fighting words doctrine, if you could even call it that, goes out the window. This is a very, very weird defense. They're basically, if I understand it right, going to suggest that Jeremy is a meanie and therefore Matt punching him was justified. Not the approach I would take, but again, I'm not his lawyer, so it doesn't matter what I would do. Defendant ultimately seeks dismissal of plaintiff's unfounded and baseless claims. The defendant, importantly, has not filed a motion to dismiss on jurisdictional or any other grounds at this point. And I mean, if they seek dismissal, they might want to get on that. So that's the first section of important things. Let's move on to the next part. So that's kind of the statement of the claims from the two parties in the jurisdictional statement. That's the big update news. The next is all just management of the case. Now, in federal court, you get to choose, or well, in this jurisdiction of federal court, you have multiple tracks to choose for the case, which involve different dates and timelines and stuff, depending on the type of case you have. In this type of case, you're probably not going to have like a lot of expert witnesses or anything like that. Most of your testimony is going to be eyewitness testimony, and you're going to be reviewing evidence that's pretty much publicly available, or at least at one time was publicly available. So the track that they've chosen is track 2. I'm not going to go through the other tracks, but I will show you what the track 2 track looks like and the dates that are involved. Here we are. Dispositive motions are expected and shall be filed by September 19th, 2019. So that gives you a clue as to how long out we are on this trial. So dispositive motions are motions that would dispose of the questions at issue. So a motion to dismiss is dispositive because if you win the motion to dismiss, it's gone. Motion to summary judgment is also dispositive because if you make a motion for summary judgment, then the case is resolved. Okay, so that's a dispositive motion. Those are due and shall be filed by September 19th, 2019. Then, when you file a dispositive motion, the other party has like 28 days to respond, or 20 days or something like that. And then you have a couple days to respond back. And then the judge has 30 to 90 days to rule on those motions. And that's only if argument isn't heard. So that September 19th sets out an idea of where that timeline starts to stop. And then you can add a couple months to that before you get a result. Non-expert witness discovery and discovery relating to liability issues shall be completed June 19th, 2019. So that's if they're looking for witness statements, depositions from eyewitnesses, depositions from people who, like the bar owner or anybody who might have information on social media. They would want to gather all that discovery by June 19th. Also, any liability discovery. So if Loader is looking for the medical records to back up the medical portion of Hambly's claims, they would have to submit that discovery questions around that to Hambly by June 19th. Expert witness discovery and discovery relating to damages completed on September 19th, and all remaining discovery completed by October 19th. The next one is witnesses. All parties shall file and serve their final witnesses and exhibit lists on or before October 18th. So right before the final discovery date deadline, they'll file those witnesses lists. You don't get to surprise people with who is a witness. That's what happens in movies. Very rarely does that happen in real court unless you come up with information unexpectedly during trial. Usually everybody knows what's coming. They also say it should list as specific witnesses. Party may call it trial. And also the final witness shall include a brief synopsis of the expected testimony. So again, the whole like TV gotcha, surprise, this witness said everything, now the case wins. Like that's not very common. People tend to know what's going on going into these things. All right, trial date. The parties request a trial date in January of 2020. So we're 11 months out from a trial date. trials by jury and anticipated to take 3 days. And there's some other stuff, but that's the important part of this section. Again, I just wanted to impress upon you guys, if you're following along at home, this case is about to get really, really boring and quiet for a while as discovery commences and stuff like that. I mean, we may have some dispositive motions come out here and there, but on the whole, it's going to be a whole lot of waiting, and trial will be in January. They could, of course, settle at any time before this. Whether or not they will remains an open question. Finally, here's a signature block, and I only wanted to put this in here to let you guys know that /S/ indicates an electronic signature because all the courts require electronic filing now. But it is signed by both plaintiff and defendant's counsel. So this is not an adversarial document, so no one should be accusing me of presenting one side of the story over the other. The sides of the story that are presented here in those summary statements were crafted by each of the parties and put in. The timelines are all agreed. These are not proposals that the other party is going to get to oppose. Only if some new information came up or there was some sort of purposeful delay or contempt of court that happened would any of this stuff likely be changed without both parties consenting to it. So that's where we are, guys. As a recap, jurisdiction is good. It will be held in that court. It will be held by the magistrate that's currently been ruling on it. All of the motions currently are set to be held by the magistrate judge as well. That could be changed to a district court judge if necessary, but typically it's going to be the magistrate judge handling all of this case. We've got Hambly laying out that he was punched. We've got Loader not denying the punching, but denying that he's responsible for damages and saying that Hambly is responsible for the damages either due to negligence or unclean hands. They've got some indications that they may file a motion to dismiss. It hasn't happened yet. We've got a long way to go on any trial and on discovery. So I hope you guys found this video informative. If you don't know what this case is, check out the other videos in this playlist for kind of a rundown on that. But I just wanted to put out this short video to help you guys understand where the case was and understand why we might not be hearing a lot about it for a while. We'll see. But big news, having the jurisdiction solidified. I really think that was Matt Loader's biggest hope, was that the judge would say that they don't have jurisdiction based on the amount in controversy. They chose not to oppose it, so it's done. It is done, and now they have that. Now we just have to go on and find out if Jeremy can put up evidence that Matt Loader did, in fact, hit him. And from what I understand, what I hear, there's a good amount of evidence. But I don't know. We'll see. What do you think? Throw it in the comments below. If you're not a subscriber to this channel, subscribe, follow along with this case and several other cases, or join me on a live stream for some laughs. Thanks, guys. I'll talk to you soon. Peace.